Welcome back to online classes. Dear students, how are you? Today also I am discussing with Indian Penal Code, but this very important section, because we already discussed the same section, but today amendment section, amendment of the punishment of rape, section 376A. Okay, 376A of Indian Penal Code explain about punishment for causing death or resulting in persistent vegetative state of victim. Here punishment for causing death or resulting in persistent vegetative state of victim. What is that? As per this section, whoever commits an offence punishable under subsection subclause 1 or subsection subclause 2 of 376A of IPC, and in the course of such commission inflicts an injury which causes the death of the woman or causes the woman to be in persistent vegetative state, shall be punished with rigorous imprisonment for a term which shall not be less than 20 years, but which may extend to imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life or with death. Okay, and prior substitution by section 9 of the Criminal Law Amendment Act 2013 with effect 3rd February 2013, this section 376 subclause A stood as the following sections. I'll give you the same section amended. So section 376A now presently act saying that whoever has sexual intercourse with his own wife who is living separately from him under a degree of separation, that means judicial separation, or under any custom of usage without her consent, shall be punished with imprisonment of either description for a term which may extend to 2 years and shall also be liable to fine. We just a comparison earlier act and after the amendment act. What happened now itself? Entirely changed. Before that is only 20, now 2 years. Okay, so the presently we are following 2 years of punishment only as per this section. Here, as a trial for rape, as per this section, the accused asked the judge to give his ruling on the point where a husband could be convicted of raping his wife, where the parties are living apart at the time. The judge held that common law rule of marital exemption, that a man cannot be guilty of raping his own wife, applied to the facts. Okay, most of the court, as per the Evidence Act section 9 of the Evidence Act, proving fact only. The report did not show the cause of their living apart. Thus, decision should be taken in the light of the declaration by the House of Lords that a husband can be guilty of raping his wife. Okay, so this edited under this preceding section exception category, that is rape by husband, edited. Okay, and also the legislative intent in the changes introduced in section 375 and 376 of IPC, introduction of section 376A to 376D in 1983 has been restated by the Supreme Court in Mogan Anna Chavan vs. State of Maharashtra. Okay, I think now it clear this section. We'll go to another section. Now section 376B of IPC explain about sexual intercourse by husband upon his wife during separation. That means judicial separations. So here also comparison of this prior act and earlier act. So first we discuss about the amendment of 1983 Act first. Later we'll discuss 2013. Okay, here 376B explain about whoever has sexual intercourse with his own wife who is living separately, whether under a degree of separation or otherwise without her consent, shall be punished with imprisonment of either description for a term which shall not be less than 2 years, but which may extend it to 7 years, and shall also be liable to fine. In the section, as per the section explanation, sexual intercourse shall mean any of the acts mentioned in clause A to D of section 375 of IPC. Okay. So, and also prior to substitution by section 9 of the Criminal Law Amendment Act 2013, the same with effect 3rd February 2013, the 376 subclause B stood as under following section, the same section only, but the act also amending. So here section 376B explain about whoever being a public servant takes advantage of his official position and induces or seduces any woman who is in his custody as such public servant or in the custody of public servant subordinate to him to have sexual intercourse with him, such sexual intercourse not amounting to the offence of rape, here shall be punished with imprisonment of either description for a term which may extend it to 5 years and shall also liable to fine. See, and here as per this act, no court shall take cognizance of offence punishable under section 376B of the IPC, where the persons are in marital relationship except upon prima facie satisfaction of the facts which constitute the offence upon a complaint having been filed or made by the wife against the husband. Okay, the following ingredients to be followed as per the section 376B. Number 1, the accused must be public servant. Okay. Number 2, he must take advantage of his official position. Number 3, he must induce or seduce any woman. Number 4, such woman must be in his custody in such capacity or she is in the custody of public servant subordinate to him. And 5th point, he must have sexual intercourse with her which does not amount to the offence of rape. It may be assumed that the appellant being a teacher, and the example of this section, here it may be assumed that the appellant being a teacher of a government school was a public servant. It's right as per the IPC. But all the students of the school only thereby were not in the custody of the appellant. Here appellant means the evicting persons. As per this discussion of this case, the expression custody implies guardianship. A custody must be lawful custody. The same may arise within the provisions of the statute or actual custody conferred by reason of an order of court of law or otherwise. When these two ingredients are satisfied, the third ingredient therefore would be as to whether the public servant has taken advantage of his official position. If a student and a teacher fall in love with each other, the same would not mean that the teacher has taken undue advantage of his official position. Even then, there must be an inducement or seduction by a public servant so far as the woman in custody is concerned, sexual intercourse. Therefore, for the purpose of attracting section 376b must take place at a place where the woman was in custody. In this case, the prosecutrix categorically admitted that the same did not take place within the precincts of the school but outside the school. So, the ingredients of the offence under section 376 of B were not satisfied in the instant case. Okay. And custody means in this portion, custody implies guardianship. It must be a lawful custody either under the provisions of an act or under the order of a court. Okay students, we'll go to another section of the same section, same IPC, section 376C, subclause C. Okay, here section 376C explain about sexual intercourse by a person in authority. That means whoever being in a position of authority or in a fiduciary relationship or a public servant or superintendent or manager of jail, remand home or other place of custody established by or under any law for the time being in force, or women's or children institution, or on the management of your hospital or being on the staff of hospital, abuses such position or fiduciary relationship to induce or seduce any woman either in custody or under his charge or present in the premises to have sexual intercourse with him. Such sexual intercourse not amounting to the offence of rape shall be punished with rigorous imprisonment of either description for a term which shall not be less than 5 years. Okay, shall not be less than 5 years, but which may extend to 10 years and shall also liable to fine also. So as per the section, we have 4 explanations under this category. I'll give you first explanation as per the section. The sexual intercourse shall mean any of the acts mentioned in class subclass A to subclass D of section 375. Okay, we already discussed with ingredients, that is ingredients. The explanation 2 for the purpose of the section, explanation 1 to section 375 shall also be applicable. Explanation 3 here, superintendent in relation to jail, remand home or other place of custody or women's or children's institutions includes a person holding any other office in such jail, remand home, place or institution by virtue of which such person can exercise any authority or control over its limits. Explanation 4, the expression hospital and women's or children's institutions shall respectively have the same meaning as in explanation to subsection subclass 2 subsection 376 of IPC. And also this act also prior to substitution by section 9 of the Criminal Law Amendment Act 2013, the same with effect 3 February 2013, and also this section also stood as follow 376. So as per the amendment of Criminal Act section 376, whoever being the superintendent or manager of a jail, remand home or other place of custody established by or under any law of the time being in force or of a women's or children institution takes advantage of his official position and induces or seduces any female inmate of such jail, remand home, place or institution to have sexual intercourse with him, such sexual intercourse not amounting to the offence of rape shall be punished with imprisonment of either description for a term which may extend to 5 years and shall also liable to fine. Now, before the 2013 Amendment Act, how much here? Not less than 5 years and extended to 10 years. But now, after the 2013 Amendment Act, how many years of imprisonment? Extended to 5 years. That's all. Okay. Shall also be fine. Okay, students. And also, as per the amendment of 2013 Act, I'll give you two explanation about the section 376 subclass B of the IPC. Explanation 1 is superintendent. That means in relation to a jail, remand home, or other place of custody or women's or children's institution includes a person holding any other office in such jail, remand home, place or institution by virtue of which he can exercise any authority or control over its limits. And as per the section's explanation 2, the expression women's or children's institution means shall have the same meaning as in the explanation 2 of subsection 2 of section 376 of IPC. Okay. Okay, students, and also we'll discuss another section of the same provisions. Section 376 subclass D explain about gang rape. This also peculiar type in our modern society. Many of the peoples are doing like this, and educated and uneducated peoples also doing the same offense. There is no difference between and all. So our legislator, as per the section 376 subclass D, where a woman is raped by one or more persons constituting a group or acting in furtherance of a common intention. Note down, here is a common intention as per the section 34 of IPC. Each of those persons shall be deemed to have committed the offence of rape and shall be punished with rigorous imprisonment for a term which shall not be less than 20 years, but which may extend to life, which shall mean imprisonment for remainder of that person's natural life. Okay, and with fine also. So provided that such fine shall be just and reasonable to meet the medical expenses and rehabilitation of the victim, and provided further that any fine imposed under this section shall be paid to the victim also. So prior to substitution by section 9 of the Criminal Law Amendment Act 2013, the same, we already discussed the same provisions, effective from 3rd February 2013, and section 376 subclass D stood as under intercourse by any member of the management. Okay, intercourse by any member of the management or staff of your hospital with any woman in that hospital. So, and also explain about this act, whoever being on the management of your hospital or being on the staff of your hospital takes advantage of his position and has sexual intercourse with any woman in that hospital, such sexual intercourse not amounting to the offence of rape shall be punished with imprisonment of either description for a term which may extend it to 5 years and shall also liable to fine. Here, as per this, after the amendment provision of 2013, the explanation, the expression hospital means shall have the same meaning as in the explanation 3 to the subsection 2 of the section 376. Okay, so as per these provisions, the section 376A to 376D inserted by the Act of 43 of 1983 were sought to deal with such cases which were not covered by under section 376. So they have thus been inserted meet a situation which was otherwise not provided under section 376. Okay, a new offence against public servants has been created under section 376 subclass 2 subclass B and 376 subclass B and 376 subclass C of the Penal Code. intercourse by a man with his wife during separation, and by any member of the management or staff of your hospital with any woman in hospital would be the offence falling under section 376A and 376D of the IPC. Okay, here a distinction must be made out between offence of rape as contained in section 375 of IPC. What is the 375 of IPC? That is definition of the IPC. Okay, so which is punishable under section 376 of IPC as an offence of sexual intercourse with a woman in the situation specified in the section 376 subclass B, 376C and 376D. So the distinction is that whereas under section 376 subclass 2 there is no consent at all. Okay, under section 376B, 376C and 376D of the IPC there would be a consent on the part of the prosecutrix, but such consent has been obtained by taking undue advantage of a position as a public servant, a superintendent or member of the management. Okay, so section 376B to 376D stricto sensu, that is legal maxim. Therefore, do not deal with rape act is understood in its ordinary sense. The accused a team leader. Okay, I'll give you. Accused is a team leader and night staff nurse at a private nursing home. Here pleaded guilty to the offence committed against a paranoid schizophrenic resident in his care during a night shift. Here the accused was of a previous good character. Note that point. Many of the accused person acting as a good character, after that only he is involving this type of offence. Okay, so we have practically seen in many courts, many cases. Here in this case the Attorney General contended that the sentence should be increased in view of the aggravating features including the vulnerability of the victim and the position of the accused of utmost trust. The accused argued that suspended sentence was reasonable due to the exceptional circumstances of the case and in particular the consequential reunification of his professional career. So here it was held that sentence was unduly lenient. Okay, a sentence of 6 months imprisonment was substituted, every allowance having been given for previous good character. The guilty plea and the double jeopardy. You know meaning of the double jeopardy? Any one of the person not punished by the same offence twice. Okay, as per the constitutional law. So here the court was applied here. The imprisonment was inevitable having regard to the gross breach of trust, the circumstances of the instant case and the consequences to his career did not amount to exceptional circumstances justifying as suspended sentence. Okay, students, and last section of this amendment act, because this amendment act is very important nowadays. Many of the police station and many of the court also dealing it very strictly in all over India. So the last section 376E. This 376E explain about punishment for repeated offenders. What is the meaning of repeated offenders here? Those who are already punished by the law, the same person repeatedly doing like this. So whoever has been previously convicted of an offence punishable under section 376 or section 376A or section 376D and is subsequently convicted of an offence punishable under any of the said sections shall be punished with imprisonment for life. That means life imprisonment up to death of life, which shall mean imprisonment for the remainder of that person's natural life or with death. Okay, students. Now I am closing this session. Okay, read with carefully watch regularly in our online classes. Stay in your legal mind. Okay, bye. Thank you.